paradoxically they benefited from the false statement, that they leave well enough alone. Why should they put themselves through this excruciating process of a lawsuit when they're net ahead already? The other privilege is the Dorsey, the one that lost Dorsey's case for him. The fair report privilege was known as the fair report privilege at common law, and in California it is codified as Section 47D of the Civil Code that grants a privilege for a fair and true report in a public journal of a judicial, legislative, or other public official proceeding. And if it is a fair and true report of what happened in court, in the legislature, or in some other public official proceeding, then it is privileged. And in California, that privilege is absolute in the sense that it doesn't make any difference whether the publisher knew it was false, as long as they got it right about what was said in one of those public forums. Even if it was malicious, the publisher wanted to trash the plaintiff's reputation and knew that it was false, it's nonetheless privileged if it's a fair and true report of what happened in one of the judicial, legislative, or other proceeding. Then in Dorsey, there were a couple of wrinkles on that, and Dorsey said, well, the privilege doesn't apply here because the New York family court proceedings are not public. They're private. They're secret. So the privilege doesn't apply to what's said in those proceedings. Only applies to what happens in open court and so on. But the Ninth Circuit looks at how California law governed this case, how the California courts had interpreted that privilege, and they found precedents, precedents. They found precedents that established, for example, that FBI rap sheets were within the privilege, or more importantly, grand jury proceedings, which are secret. And if the press reported what happened in a grand jury proceeding, that was held to be within this privilege. Well, the grand jury proceedings are secret, the family court proceedings are secret, they can't be treated differently. And so the court read the statute, interpreted the statute, where it says public, judicial, legislative, or other public official proceeding. They read the word public to mean government. As long as it's a government proceeding, the privilege applies. And in Dorsey's case, the privilege applies to what's said or done in this family court proceeding. Therefore, Dorsey loses. But Dorsey says, wait a minute, the National Enquirer didn't just report what happened in court, the affidavits that were filed in court. They went out and they interviewed this woman, and they interviewed her private detective, and quoted them. And that wasn't in court. That's not a fair summary of what was said in court. Well, the Ninth Circuit dispatched that one too, relying on the way the California Supreme Court had interpreted this same privilege in prior cases, looking to the natural and probable effect on the mind of the average reader who would read this, and asked whether the gist or sting of what was quoted out of court was any different from the gist or sting of what was said in the court proceedings. And if the average reader would have said, well, geez, that goes way beyond it, that's entirely different from what was said in court, then the privilege wouldn't apply. But the court said, and the California courts had previously said, the press doesn't have to give a verbatim account of what happened in court, word for word, in order for it to be fair and true. They have some literary license to interpret what happened in court. They need breathing room, the court said, to convey to the public what happened in court. So they don't have to limit themselves. They can explain what happened in court. And then if you look at the gist or sting of what happened in court and compare that to the interviews out of court, what was the gist or sting of what was in court? That Dorsey had AIDS. That was the thrust of what the proceedings in the court were all about. By the way, he didn't have AIDS. I don't know if you noticed the footnote, but he was promptly tested and it was false. He did not have AIDS, didn't have the virus at all. Compare the thrust of the article with the interviews outside of court. What was the gist or sting of them? Well, it was the same. He really does have AIDS. We're sure he has AIDS. And so the court said it wouldn't make any difference on the mind of an average reader that part of the National Enquirer's report was based on information that was not actually presented in court. The fair report privilege is a great friend for the press. I mean, you will see in innumerable news stories that will say, Joe Blow committed securities fraud, fleecing thousands of investors of their hard-earned savings, comma, according to a lawsuit filed in federal court yesterday. And if that fairly and accurately captures the allegations of the complaint, unproved complaint filed in court, it's within that privilege. So it's a very handy, quick and dirty defense for publishers to get out of libel suits by basing their reports on what happens in some government proceeding. In court, very frequently, true. In the legislature, somebody will get up and accuse somebody of something awful on the floor of a legislature, or in a legislative hearing, or in a city council hearing. All privilege. And a great, that shows the enduring utility of the common law here. We're not talking about First Amendment protections. You can get rid of this libel suit on the cheap if you can demonstrate, for example, that there's no defamatory meaning, or that it's not about the plaintiff, or that it's privileged. If you're going to get into the thicket of whether it's true or not, that's not the quick and easy way out of the suit, because there's going to be lots of back and forth, he said, she said, on the truth, by and large, in most cases. But some of these other elements of the common law, like the fair report privilege, provide easy ways for publishers to avoid getting sued successfully for libel. And then fault is the last question. Is that an element of the common law? You guys pounced immediately on what would be considered fault. Knowledge of falsity, deliberately lying, malicious intent, wanting to hurt somebody. That's fault. That's blameworthy behavior. And by and large, in American tort law, some kind of blameworthy state of mind is required. Negligence is a blameworthy state of mind. You didn't act the way a reasonable person would in the circumstances. Malice is blameworthy. Deliberately hurting somebody, intending to hurt somebody, all of those are examples of fault. And most torts require some showing of fault, usually intent to hurt somebody, to cheat him in fraud, for example. Libel, at common law, was a no-fault tort. You didn't have to prove any of that in order to win the case at common law. You didn't have to prove malice, knowing lie, malicious intent, negligence, recklessness, none of that. If it was published, it was false, it was defamatory, it was other concerning the plaintiff, and it was unprivileged, you win. You might want to prove fault, that it was malicious and so on, in order to try to recover punitive damages, which are intended to punish the wrongdoer, deter wrongdoers from doing stuff like that. You might want to prove that somebody deliberately lied, but you don't have to. Didn't have to at common law. Yeah. The defendant in Dorsey, you're talking about? Or, yeah, the National Enquirer. They won the case. Why did they win the case? Helpful to review that. Why did the National Enquirer win the case? They published this false information about Dorsey. Published, it was false, it had defamatory meaning, it was of and concerning him, but it was privileged, under the fair report privilege. In order to win the case, all five have to be met. The five, I have to tell you, is a little oversimplified, and there are a lot of wrinkles on all of these things, but those are the main elements of a claim for libel, those five, not including fault. 1963. 1964 is a different picture, because Sullivan changed all that. Sullivan, of course, did not apply in England, and what our courts say doesn't govern what is in England, and England still has the common law rules. And that has made England a haven for libel litigation. That is, people who are defamed in the United States will look to see whether that book that defamed them also was distributed in England. And if they were, they might go to England to file suit. Why would they do that? For one thing, they don't have to prove falsity. The common law rule is truth's a defense, so much easier to win your suit. You don't have to prove falsity. And second, in England, you don't have to prove fault. The common law rules still apply. Whereas here, it's much more strict, and it's strict because of the First Amendment rules that Sullivan superimposed on the common law of libel. Okay, I can imagine that your heads are swimming. Is there anything we can clear up right now? No? Okay. Tuesday, it's the great case of New York Times versus Sullivan.